sector. So I welcome you all. Today we have with us Dr. Harsh Mahajan, our senior leader and mentor for FICCI Health Sector. He's the founder and chairman for Mahajan Imaging and Labs. We also have Mr. Tishampati Sen, the expert lawyer and advocate for Supreme Court of India. We have Dr. Narayan Pense, Senior Vice President for Medical Strategy and Operations with Fortis Healthcare, and Ms. Anasuya Mohan Rao to give the medtech perspective. She's the Clinical Partnerships Leader and Clinical Science Leader at Philips Healthcare. Thank you everyone for joining today. And now I request Dr. Harsh Mahajan to kindly give the opening remarks for the webinar.
Thank you very much, Shilpa, and good morning, everyone. Welcome to this very important webinar on the DPDP Act 2023 and rules which have been framed recently in 2025. And really, FICCI has taken the lead in trying to decipher the implications of Digital Personal Data Protection Act for India's health sector. As we meet today, the Indian healthcare system stands at a transformative crossroads. Digitization, which once felt like the future, is now the present reality of healthcare. Hence, this conversation could not be more timely. Today, more than 800 million digital health records have already been created under the Ayushman Bharat Digital Mission, and more than 70% of tertiary hospitals use some form of electronic medical or imaging system. Telemedicine has crossed millions, hundreds of millions of consultations nationally. Every one of these interactions generates sensitive personal data, data that speaks to a person's health, identity, and most importantly, dignity. Healthcare, as we know, unfortunately, is also the most targeted sector globally for data breaches. Nearly 1/3 of all cyber incidents worldwide involve health data, and India has seen a sharp rise in such attacks in the last few years. This makes the DPDP Act not just a legal framework, but a critical safeguard for patient trust. The Act actually places the patient firmly at the center, introducing meaningful consent, giving individuals the right to know and withdraw, and requiring healthcare institutions and technology partners to handle data responsibly. For a sector built on the sanctity of confidentiality, this Act aligns with our ethical commitments while also demanding operational discipline. At the same time, the Act raises practical questions for all of us. How do hospitals and diagnostic centers, and for that matter, even small clinics, manage consent across OPDs, emergency care, labs, and telehealth? How will small clinics, nursing staff, and allied health teams implement these requirements? What happens with imaging data shared across radiologists, cloud-based platforms used by device companies, or AI tools that learn from clinical patterns? And how do we balance compliance with innovation? There is also the question of data storage, whether global cloud platforms can still be used, and how multinational medtech or pharma companies will adapt. Equally important is harmonizing DPDP Act with existing healthcare regulations so that compliance becomes clear and not burdensome. These are crucial issues, and today's speakers bring rich expertise to help us navigate them. I'm grateful to all three, Mr. Tishampati Sen for joining us with the legal perspective, to Dr. Narayan Pense for insights from hospital operations, and to Ms. Ansuya Mohan Rao for bringing the technology and medtech lens, and also innovations, startups, how are they to deal with this act and in the transformed environment. As we begin, I want to emphasize that data protection is not merely compliance. It is an extension of our duty and care of our moral system that we have in healthcare. When patients share their most sensitive information with us, they are placing immense trust in the system. Upholding that trust is essential for the future of digital health in India, and also from avoiding the legal hurdles, the legal hassles that we may get into in case we are not careful. Thank you once again for joining. I see already we have over 235 people who have joined, and this really brings home the fact that we all realize in the healthcare sector that this is a very, very important act. This is going to probably change the way we practice medicine, the way we store data, the way we share data, and we have to be mindful that it is the patient, his privacy, which is at the center of all of this. Thank you all for joining, and I really look forward to a meaningful discussion. It's my pleasant duty now to invite one of the foremost practitioner of law, a youngster, though his hair is graying, who actually from being the head boy of his school, DPS Arkepuram, where it's tough to become the head boy, to actually becoming a first generation lawyer, has done exceedingly well. Tishampati Sen is an advocate, Supreme Court of India, and he will give a presentation on the implications of the Act. He has extensive experience in constitutional and regulatory matters with a strong background in legal interpretation and advisory. He has been closely involved in analyzing the legal contours of the DPDP Act and its implications for our sector, that is healthcare. So over to you, Tisham. Take it from here with your presentation, and then we will, for the information of all that who've joined, and it's already 2:48, we will then have a panel discussion where the other two participants will join in with their own questions and interaction, and then you are most free to send your questions on the chat box, and I'm sure our three panelists will be able to answer them. Thank you very much, and over to you, Mr. Sen.
Good morning. Good morning, Dr. Mahajan. Good morning, Ms. Rao. Good morning, Dr. Pense. Good morning to everyone here. And thank you so much, Dr. Mahajan, for this lovely introduction and for drawing attention to my white hair, especially that was, that was very sweet. Let me, first of all, completely agree with you that yes, this is a watershed moment in terms of legislation, in terms of data protection. It brings the balance back to the individual. It tries to reduce the chasm between an individual and a corporate, an individual and an institution like a large hospital. And it helps to foster a culture of privacy and respect for individual rights, which I think is a very, very important move. And there is a certain amount of seriousness to this act, which helps because it makes all the businesses take this very seriously. I also agree with Dr. Mahajan when he said that there is also a duty of care for the health sector to be aware that we have in our possession extremely sensitive data that has been considered sensitive right from the time of the IT Act, the Information Technology Act. So it's been, that culture has been there for a while, but this act brings with it certain enforcement mechanisms, which requires all of us to take it very seriously. But there are some ambiguities. And with every new law, which is not tested in the industry or before a court of law, there are ambiguities, there are more questions. And I think it is more important for us to ask the right questions and brainstorm on these than look for answers at this stage. With that, let me just start straight away into the Act and how the Act is presently placed, the Act along with the rules. We have the new privacy regime, which is enforced in terms of the Digital Personal Data Protection Act, which for our discussion purposes, let's call it the DP Act, which was notified on the 11th of August 2023, and the DP rules, which have now come up on 13th of November. Why is that important is because the rules now starts the clock for compliance. And we have 2 or 3 key phases where the entire rules and the act and the legislation becomes effective within in a phased manner. Phase 1 is where the data protection board has been set up. The data protection board has been notified to contain 4 members. It will be based in the NCR region, and it is being called a digital board in the sense that all your grievances, all compliances, all data shall be shared digitally with them. One can monitor the case digitally, and the board has wide powers. In a sense, the board is an independent body which will oversee compliance. It will inquire into breaches and shall ensure that corrective measures are taken. And it takes a key role in enforcing the rights granted under the Act and maintaining trust in the system. It's an extremely important component of what will be enforcing this entire mechanism in the country. The second phase is where the consent manager comes up. If you see this, the transition phase is an 18-month period, but within a year from now, we will have a consent manager, which is like an independent body. It's a regulator, it's an aggregator rather, which will allow for consent to be provided on their system, as well as put all the consents together. The most important phase is over an 18-month phase where all the effective provisions of the Act as well as the rules, such as Section 3, 4, 5, 6, and so on, and the associated rules become effective on 13th of May 2027. And it is in preparation of that we have to start taking measures to be in compliant with that as of 13th of May 2027. Now, one of the questions that came up and has often come up is, who does this act pertain to? Does this legislation pertain to? And one of the questions that have also, been considered from time to time is that will it depend on the size of the organization, the sector, the kind of service being provided? Presently, the only answer that seems to be is that this act is applicable every time that there is an individual's data that is being taken in digital format for the provision of any service. It is sector agnostic, size is irrelevant, and the nature of business is irrelevant. So therefore, every single organization, including maybe even small nursing homes, will have to comply with this data regime. Now, there are some core concepts under a DPDP Act. And I know there have been a lot of talk, a lot of articles. So we are all aware of these definitions, but I'd like to very quickly go over some of these with the health sector in mind, because some of these concepts need to be understood. And more importantly, questions need to be asked as to what it actually means and how can one go about treating the specified purpose. Now, first of all, we see the definition of data. Now, data is more or less the same as the definition of data under the IT rules. However, the data here also includes the word opinions, which to me was interesting because it is rather nebulous as to what all it would bring within the definition of data. And if one looks at it right now, it's a representation of information, facts, concepts, which was also there in the earlier legislation, opinions or instructions. And then it goes on to say in a manner suitable for communication, interpretation, or processing by human beings or by automated means. So the definition of data is quite wide. Presently, I think data can include everything and anything to do with an individual as long as it pertains to that individual and one can identify the individual with it. Which brings me to the next definition, which is personal data. This is an important definition. On first blush, it seems like a very obvious extension of the word data to see any data that refers to an individual. But the phrase that comes after that, I think, is extremely important. It says personal data means any data about an individual, so far so good, and then goes on to say who is identifiable by or in relation to such data. Now, this becomes important as we later discuss from an anonymization and from a research point of view, because what the Act seems to be inclined to bring within its realm, within its domain, is personal data which you can use to identify the individual with. So the minute there is data which you cannot identify the individual with, the question that comes up is it then outside the scope of this act because of this definition of personal data? Now, data principle, we've dealt with this in several, including the previous webinar. is the person who actually owns the data, who has the custody of the data in the case of a child or in the case of a guardian of a disabled. And in the healthcare sector, it would typically mean the patient, in the insurance sector, maybe the customer, but the person, the individual who holds the data for himself. The next definition that becomes important is data fiduciary when you specially consider that in line with the data processor. So, data processor, let me deal with that to begin with, is any person who is actually processing the data, which is treating the data. Processing, we will get to the definition after this, it's again an interesting one. But processing, essentially any kind of treatment of the data that is being done, is a processor. But the processor may not always be the person responsible to the data principal. The person responsible to the data principal, who is responsible in terms of the statute, is the data fiduciary. And that is the person who actually has taken the call as to what kind of data is needed, what is the purpose with which the data is needed, and what kind of processing is going to be done about that data. This distinction may become relevant as we go along in our discussion and as we consider several questions that will come up in the healthcare sector. But the data fiduciary is eventually the person, in a nutshell, who determines that he needs the data, who determines what kind of data is needed and what format it will need to be processed in for the purposes of providing the service. Now, if you look at the definition of processing, I'm reminded that the IT rules did not have any definition of processing, although the word there was also used. The word used in the IT Act and the IT rules was processing of data, but the definition was missing. To me, the definition is interesting only for the last bit. I won't read all of it. It includes a whole set of operations that can be performed either wholly or partly in an automated manner. But please see the end, because it's important, as it says, or otherwise making available restriction, erasure, or destruction. Now, this might again be something for us to keep in mind when we consider patient records or patient data in a healthcare scenario. Because even the deletion and the erasing of data is considered as processing. Significant data fiduciary, I think one of the questions that have been highlighted from time to time is that who is going to be a significant data fiduciary? Right now, the Act simply says whoever is notified by the central government to be one. The Act also provides certain qualificative criteria, such as the nature of data, the volume of data, but there is no qualitative criteria presently provided in terms of a tangible form. So, who could become a significant data fiduciary is really not clear. The rules do not provide any clarity to that. I expect the government will, from time to time, come back with notifications notifying what kind of industries, what the size of the industry, the size of the organization that will fall within this bracket. But I think it is safe to assume that large clinics, large hospitals, which have significant data, which have significant patient footfall, would err on the side of caution by believing that they will be notified as significant data fiduciary. Otherwise, there is nothing else that is tangible today for us to consider. Now, specified purpose, again, we've seen the definition. It is that purpose which is stated to the data principal. And lastly, the consent manager, as we discussed, it is the person who will be registered with the board. That registration criteria is given. Registration will start a year from now, and he will act as a single point of contact to enable the data principal to give, manage, review, and withdraw the consent through an accessible, transparent, and interoperable platform. It is essentially in the nature of a account aggregator. Now, with this, let me go straight away to section 3. This is an important section as to who it is applicable to. It applies to all data which is collected in digital form, but more importantly, please see 3A2. It is also applicable to all data that is collected in non-digital form, but digitized subsequently. So if there are any scans being made, if there are any copies and then maintained in a soft copy format pertaining to individual data, that should also fall within the bracket of this Act. It is also applicable to processing of digital data outside the country if such processing is in connection with any activity offered for goods or services to data principals within the territory of India. Now, it's an interesting clause, it's an interesting section 3B. I have read somewhere, a lot of people are saying that this Act brings the power back to the citizens because the citizens have a certain confidence over their data. I'll go one step further. This act actually applies to everyone. If you read 3B, any person, citizen or a foreigner, who is in India and getting a data processed in India, or who is outside but has goods or services being provided within the territory of India, this act remains applicable. And to that extent, I think it's a very mature and a very pragmatic view taken by the legislature in giving such a provision where it is not only towards the citizens, but anybody who has an interface with any service provider in India and is providing data. It is not applicable to those to that personal data which is being processed for individual personal domestic use. Therefore, if you and I decide to store some data for our own consumption on some drive somewhere, that is not going to be applicable. Now, for healthcare service providers, these forms that will have to be signed, the data that will have to be provided. I know a lot of healthcare providers are also putting prescriptions online. These scanning the soft format of these of the data will become relevant and will be applicable for as far as this statute is concerned. I'll go straight away to data fiduciary and a significant data fiduciary. As we discussed, Section 10 mandates who will be a significant data fiduciary. Presently, Section 10 does not provide for what will be the criteria. It gives a whole indicative criteria, but nothing really significant, including volume sensitivity. If you are called a significant data fiduciary, if by notification you determine that you will fall into the bracket of a significant data fiduciary, which I think most hospitals, large hospitals and clinics should prepare themselves for, then in addition to the duty of a data fiduciary, you will have certain other obligations like taking periodic data protection impact assessment and having compliance audits. The data fiduciary otherwise has obligations to make sure that the data that is in their custody is safe. The confidentiality is maintained. Now, on confidentiality, there's a very interesting point. The entire act is silent on the aspect of confidentiality. It talks about consent. It talks about the fact that processing can happen only if it is lawful. It talks about legitimate reasons, which we'll all come to later. But it does not talk about confidentiality being maintained. Why that becomes relevant is, on first blush, it would seem that this act is not really looking at confidentiality, but it is looking at usage of data. The only indication that confidentiality is a part of it is when you come to the definition of personal data breach. And I don't think that's in my slide, so I'll just quickly read that out. The personal data breach, just give me 1 minute. Personal data breach means any authorized processing of personal data or accidental disclosure, acquisition, sharing, use, alteration, destruction, or loss of access to personal data that compromises the confidentiality, integrity, or availability of personal data. And it is through this one definition that we have to read in confidentiality as one of the obligations as far as patient data is concerned for all businesses, for all entities in terms of this act. Now, as far as the obligations of data fiduciary are concerned, it is very expansive between sections 8 and some of the other sections that are mentioned there. And essentially, it is to say that you must protect the data, you must notify. Notification is a very, very important part of the duties that are provided upon the data fiduciary. You have to immediately inform the board and the data principals if there is a breach and what is being done to prevent it, what is being done to remedy it, and what is being done to prevent any recurrence of it. The breach of your information responsibility has its own penalty, which goes up to 200 crores. So it's an extremely important requirement. It's an important duty upon the fiduciary to notify the board and the data principal the minute there is a breach or a potential breach of the data processing requirements. Then there is to also provide contact information for grievances such that the data principal, if they feel that any rights of theirs have been violated, if they have not received information from the data fiduciary within a period of 90 days, then they can take it up with the board and the grievance officials of the organization. Finally, it is to erase data. Now, this is an extremely important provision, and this requires its own discussion. First of all, the Act mandates in several provisions that if the data principal reaches out and says, please delete my data, or I want to withdraw my consent, then there is a certain treatment of it provided, which states that upon withdrawal, the data fiduciary shall stop processing the data. And the consequences of such withdrawal will be borne by the data principal. It also, however, has a line which says that if it is withdrawn, and I'll just read this line for you and we'll come back to it later. It says that unless such processing without her consent is required or authorized under the provisions of this act or the rules made thereunder. Now, keeping that in mind, we'll consider what processing is and what kind of services are being done. The other aspect is evasion. So, if the data principal under section 8 reaches out and states, please erase my data, the data fiduciary is obligated to do so. However, it states it shall erase the personal data as soon as it is reasonable to assume that the specified purpose is no longer being served, whichever is earlier. Now let's look at it for a minute. If I received information, if I receive intimation that I have to erase, one, the data fiduciary will have to erase it. If you do not receive information that I have to erase it, the Act today provides a certain time period for certain identified industries which would erase the data after the prescribed time period. And I'll come to that schedule 3 in a minute of the rules, which say that, for example, e-commerce platforms will have to delete data after 3 years if they haven't heard from the data principal and the data principal is not taking their service. But it is silent on healthcare. It does not state how long the healthcare industry, how long clinics, hospitals, etc. have to hold on to the data. It does not provide a minimum date. It does not provide a maximum date. It therefore states that whenever it is clear that the specified purpose is no longer being served, one can delete the data. But here I come back to the definition of processing, which includes erasure and the deletion of data. If I have to delete data, that also falls in my, it's maybe a conservative view. It's a very safe view, maybe a hyper technical view, but a view that I think one needs to consider. If deleting data is considered processing, and for all processing one needs consent, then by that logic, it would apply that in your consent forms, healthcare officials must now specify that if we don't hear from you, if we are providing service and that comes to an end within an X period of time, I will hold it in compliance with other laws that are applicable to me, post which I have your consent to delete it. The deletion must be provided for in the consent form because we don't want to be in a situation where somebody else comes back and says that Schedule 3 did not provide for you, it did not prescribe a time period, and deletion is also part of processing, which we'll come to that in a second. Now, data principals' rights. These are all the niceties of the Act. The data principals' rights are essentially manifold. One can classify them as right to seek correction. If you see your data is incorrect, one can come back to the data fiduciary, ask for it to be updated, for it to be completed, and for it to be corrected. The data principal also has a right under Section 11 to come and ask for information as to how his data has been used, or in the case of this Act, since the word is her, to ask how her data has been used, how her data has been processed, and which other entities it has been shared with. That is an important thing to keep in mind because this kind of data will have to be kept readily available by each of the businesses, by each of the participants in the healthcare sector, because it is a statutory right under Section 11 for the data principal to come and ask for a complete report as to which data has been processed in what manner and shared with who else. Last is the right of grievance redressal. They can bring up their issues in terms of the statute. And let us keep in mind the fact that no civil court has any authority or any right over any dispute with respect to this Act. It is the Data Protection Board, which has the power to receive evidence and to give a decision and to conduct a hearing in that matter, very much like the Competition Commission. And based on that, a decision is taken, one can appeal it. Importantly, and I think this becomes relevant when one considers how attractive it would be for data principals to rush to the Data Protection Board. Unlike the IT rules and unlike the IT Act, there is no provision for compensation to be paid to the data principal, nothing that we have very quickly found. Under the IT Act and rules, there was a provision for compensation. If you have breached due to negligence, the data principal's rights as far as sensitive data was concerned, Here, it seems that if you have breached, an obligation is upon the data fiduciary to inform, and on a complaint by the data principal, the board takes it up and a penalty is imposed. It not necessarily a compensation, which is why I don't see a lot of people fly by night rushing to the data protection board, which might be a very good check and balance for this act as well. Upon receiving a request from the data principal, the data fiduciary is under an obligation to complete the data, to update the data, and erase. I think we've discussed erasure already. I don't want to deal with this any further. Now, consent. Consent becomes extremely important. I'd like to bring your attention to Section 5 before I get into Section 6. Section 5 provides that consent for this data shall be taken in a manner prescribed under the rules and under the Act. And Section 6 and Rule 3, Section 6 of the Act and Rule 3 of the rules provide the parameters and the criteria with which the consent will be taken. And in a nutshell, it is that it must be in a plain language, it must be in a language that the data principal can understand, it must be in a way for the data principal to understand on a standalone basis what data is being asked for, the specific purpose with which it is being asked for, and the description of such data that is going to be taken from the individual. Now, under Section 5(2), it says that for data which has been given prior to the commencement of this Act, there is a certain treatment for it. It's an interesting provision because it normally acts like these don't go retrospective in time. They are prospective, saying that from the date, from say 13th of May 2027, when the provisions become active, all data will be taken in a manner where consent has been taken and so on and so forth. However, this provision makes it clear that where data has been taken prior to the commencement of the Act, it states that the data fiduciary shall, as soon as it is reasonably practicable, give to the data principal a notice informing her that the personal data and the purpose of which it was processed, the manner in which she may exercise her rights under the Act, and the manner in which the data principal may make a complaint to the board. So what it states is, for all the data that you now have, and there is no look back period. It is not saying that for the last 5 years, or it doesn't even say for the last 10 years. So technically speaking, all the data that one has in a soft format, that one has in a digital format, comes under the scope of Section 5(2). Now, this is an extremely tedious task, and I think it is to the largest extent transactionally impracticable to expect large hospitals, large and even medium-sized hospitals, medium-sized clinics, healthcare providers to go back in time for all the data that they presently have and to take permission with respect to that data. Because again, my worry is, since the word deletion is finding its meaning in processing, one should not be able to process without taking consent. Now, that is why I feel this section will have to be at some stage clarified either by the government, by notification, or by the courts. And a certain restriction or a stricture must be brought in as to how much is the look back period. But what is important is it says it says where the data, so and so the data fiduciary shall, as it is reasonably practicable. That I think is the saving grace of this section, because it doesn't state that you shall within a period of 6 months or within a period of 3 months, making it that much more tedious and onerous. It states as soon as it is reasonably practicable, which phrase is really open for anybody's understanding, that what is reasonable one will have to determine, what is practicable one will have to determine given where you are, given the kind of data, and you shall try your best to provide this notice giving 1, 2, and 3 to the data principals. Part B of this section goes on to say data fiduciary may continue to process the personal data until and unless the data principal withdraws her consent. So according to me, the way it should work is a notice is to be sent out. If you don't hear from them, please do with the data as you have been doing while being strictly in compliance with whatever the norms have been applicable to you, which are the IT rules, GDPR in some cases, and so on and so forth. Now it brings me to Section 6. And Section 6 is relevant, especially since Section 6 provides that it has to be free of consent. It has to be free. Your consent must not be obtained by consideration. It is to be given voluntarily, not under undue influence, not under coercion. It has to be specific. It has to be informed on a clear understanding of what the notice is asking for. It is unconditional and absolutely clear. Here is where legalese is not useful. One will have to be absolutely clear and unambiguous in terms of getting this information. But an interesting provision here is section 6.4 read with 6.6. And I'll just read out section 6.4. 6.4 states that where consent given by data principal is the basis of processing of personal data, such data principal will have the right to withdraw her consent at any time, with the ease of doing so being comparable to the ease with which such consent was given. Now, I'll read section 6.6 and then get into my thought on this. Section 6.6 continues to read, if a data principal withdraws her consent to the processing of personal data under subsection 5, the data fiduciary shall, within a reasonable time, seize and cause its data processors to cease processing the personal data of such data principal unless such processing without her consent is required or authorized under the provisions of this Act or the rules made thereunder or any other law for the time being in force. According to me, this is a slightly nebulous provision because it states that once it is withdrawn, it is not as if the service stops. And again, one will have to remind oneself that this act is not tailor-made to the healthcare industry, where the distinction between the usage of the data and the provision of the service is actually intertwined. It is also, in terms of illustrations, one would see it is targeting other online services like e-commerce, like your emails, various other services which require data, to say that the minute you ask for your data to be withdrawn, you shall stop processing that data. The minute the consent is withdrawn, you shall stop processing the data. If it makes it clear that you will not be able to provide the service, then that is a consequence in terms of section 5 that the data principal will bear. I'll just read subsection 5 also. 6.5 says the consequences of the withdrawal referred to in subsection 4 shall be borne by the data principal, and such withdrawal shall not affect the legality of processing of the personal data based on consent before its withdrawal. So it clearly states that if on withdrawal you are unable to provide the service, that's a consequence that the data principal will have to bear. Again, I am worried about deletion. Therefore, my apprehension is that deletion should not throw any of us in a situation where we have to justify that it is not processing. According to me, again, therefore, all communications upon withdrawal, upon taking consent, must include the word deletion to say that once your withdrawal, I take it that you are consenting for the data to be deleted. Because otherwise, deletion may bring us into that gray area where we don't want to be, and where we don't want to be that test case where a court or an authority decides whether deletion should form processing or not. Now, section 4 and section 7 are important sections. Section 4 says the grounds on which processing data can be processed. And one is important. It states a person may process the personal data of a data principal only in accordance with the provisions of this Act and for a lawful purpose, A, for which the data principal has given her consent, which is clear, that we are all aware of in terms of the Act. What is interesting to me as a lawyer who wants to read the language used now is or be for certain legitimate uses. The usage of the word or to me signifies that A and B are disjunctive. A and B are not to go together. Because otherwise, I don't know why the legislature would have used the word or. So if B is disjunctive from A, and if A is saying that data principal, the data can be used for that purpose which the data principal has given consent for, that is one criteria. The other is all legitimate uses. There is no definition of what is a legitimate use of data. And according to me, this is a big yawning gap in the Act where it is open to interpretation. My suggestion is this therefore has to be read along with section 7, which prescribes certain legitimate uses of data. Section 7A, as you'll see on the right side of the screen, is vanilla in as much as it says that data will be used for that purpose with which the data was collected, for which the data principal gave her consent. That is vanilla, that is in line with 4A. Then there are certain other provisions under section 7 where it states where consent may not be required. And for the healthcare sector, I think what is relevant is 7F and G, and possibly D. D is not on the screen, so I'll read it very quickly and then I'll go straight to F and G. D states D states for fulfilling any obligation under any law for the time being in force in India on any person to disclose any information to the states or any of its instrumentalities, subject to such processing being in accordance with the provisions regarding disclosure of such information as in any other law for the time being in force. In simple terms, for example, during COVID times, whether I give consent to you or not for using my data, whether I withdraw my consent, it was a requirement to report if there is a COVID positive that possibly is covered under 7D. F and G are much simpler. It says for responding to medical emergency involving a threat to life or immediate threat to the health of a data principal or any other individual. It's a very smart, mature section which says healthcare providers, if you see that it is important to save a life or there's an immediate threat, don't worry about taking consent. Don't worry about operating only with consent. Move forward. That, according to me, is what 4.1b may be intending to mean when it uses the phrase certain legitimate uses. Similarly, again in 7G, it's for taking measures to provide medical treatment or health services to any individual during an epidemic, outbreak of disease, or threat to any public health. Now, there are certain exemptions. Now, Rule 16 is an important rule, but it is extremely vague. That's the problem with the Rule 16. Rule 16 of the rules provide that the provisions of the Act shall not apply to the processing of personal data necessary for research, archiving, or statistical purposes if it is carried on in accordance with the standards specified in second schedule. Now, on first blush, Rule 16 seems to be in line with GDPR 2016, which also made an exception in the definition of processing by saying any processing done for research, scientific research, statistical research will stand outside the definition of research and will have its own criteria in terms of Article 89 of the GDPR. There is no other criteria provided for research under the DP Act or the DP rules. The only reference is to this Rule 16, which has this phrase research, archiving, or statistical purposes. The problem is, it then makes a reference to the second schedule of the rule. The second schedule of the rule is unfortunately nothing to do with research and nothing to do with any healthcare sector, because the heading of the second schedule is standards for processing of personal data by state and its instrumentalities under clause B of section 7 and for processing of personal data necessary for the purposes specified in clause B of subsection 2 of section 17. Neither of them have anything to do with the healthcare sector, and it seems to be applicable for the state and its instrumentalities. One can therefore, again, using a harmonious interpretation of Rule 16 along with the schedule that it brings reference to, would be to say that anything that is being done for research, statistical purposes stands out, provided the standard of collecting and processing such data is in line with the standard mentioned in second schedule. That, according to me, is the only way of reading it. But frankly, I think this will require some sort of clarification from the central government. Now, an important point here also is, as I mentioned right in the beginning, as far as research is concerned, I know a lot of research that happens presently is based on anonymization of data. And I think one of the industry experts had also pointed out at some stage that for developing AI, for developing your algorithms, for developing models, and for general research, a lot of data is needed from several centers. It's a multi-central approach, and you get data which is anonymized, which is pseudonyms are given. It's basically criteria as age brackets, area, kind of disease, and so on and so forth. According to me, that will not fall within the bracket of data, individual data or personal data for the definition that we discussed in the beginning, because personal data has been defined to mean such data with which you can identify the individual. Secondly, anonymization is not provided for as any sort of treatment that the Act is looking at. So what would happen in the event that data has been anonymized of an individual X along with several others, and individual X today withdraws her consent? According to me, it's an absolute gray area, because it will be impossible to even identify which is her data, which is now in the anonymized bracket of data provided to somebody else, or that is being maintained with you. In my view, the only thing that can be done is if it's like a census format, you can do a -1 to say, okay, one data is being removed, or it will have to be made very clear that your data cannot be identified. Therefore, from that pool of anonymized data, it may no longer be possible to delete yours. As far as your data bracket that we hold, we can remove that. If you want to delete it, we will no longer process the same. So the general rule is data principal, when the data must be erased when the data principal withdraws consent. Data principal asks for erasure. Specific purpose is deemed no longer to be served, as we discussed on the Schedule 3. Erasure of personal data in accordance with and after the expiry of the period stipulated under Schedule 3, which we discussed. And data fiduciary is obligated to delete personal data upon the, again, we've discussed Section 8(7) as well. I think that is about it as far as data and the consent is concerned. One important distinction that is there in the DP Act and the DP rules is with respect to minors and disabled. Section 9 provides for it. Rule 10 and 11 of the rules provide for it. But a very important distinction is there is no mandate in the Act upon any service provider to first determine that the person is actually an adult who is claiming to be an adult. So, for example, if I today claim to be an adult, even though I'm a minor, and this may not be very applicable in the hospitals and the classical healthcare sector, may be more applicable in apps for the smart devices than the wearable health devices, because there the apps is very agnostic. One doesn't really see who is signing up. If one is claiming to be an adult, the Act today does not require you to ensure that the person signing up is an adult. And it's actually a mature and a practical solution, because then everybody who signs up to an app or signs up to a service would have to go through the rigmarole of proving that they're actually an adult. So first and foremost, the Act does not require for a child who's claiming to be an adult to be verified to be an adult by the data fiduciary. Now, once there is a person who's claiming to be a child, we need the permission of the parent or the guardian as far as the child is concerned. Now, the only provision under Rule 10 is that the data fiduciary ensure that the person claiming to be the parent or the guardian is actually an adult when it comes to a child. There is no obligation to verify whether the person is actually a parent or not. This may be a certain gap, this may have been missed, but that is what the law today seems to be suggesting in terms of Rule 10 and Section 9. But it changes drastically when you come to Rule 11, which is dealing with a disabled person. With a disabled person, when a person is claiming to be the guardian, here is where the Act requires the data fiduciary to identify that the guardian is obtaining his right to be a guardian in terms of a court of law or in terms of any authorization provided by a committee. So there is a certain amount of scrutiny that is required if it's a disabled person, but a lesser standard of scrutiny required if the person who's taking the service is a child. Now, as I stated, there are penalties. Section 33 read with the schedule provided in the rules, which the board can impose if there's a violation. The maximum penalty if you failed to secure the data is about 250 crores. That's the maximum. Of course, that depends on the nature of breach, the recurrence of the breach, and the nature of data. And the maximum penalty for failure to notify the board or the data principal is 200 crores. There is no provision to provide compensation, and the penalties are cumulative and not such that if you pay 250 crores, but you will not be charged any penalty for failure to notify. It is 250 plus 200 potentially as the maximum breach. Lastly, the bits that I wanted to discuss, I think we've already covered that in terms of processing under the Act presently is vague. Yes, Section 8(2), as we've also discussed, all the data processing right now in terms of the Act is to be linked with provision of a service. There are various provisions under the Act, and I can get into that if there are any questions, which seem to suggest that all data processing must be in line with the service that you're providing with the data. Now, that begs the question that if I'm a healthcare provider, if I'm a data fiduciary who wants to store data, that is, if I want to create a database, can I call that processing of data under the Act? It would seem not, because the processing of the data in terms of 8.2 and various other provisions, seem to indicate that you will process only if the service provider, only if the data principal is getting a service on account of you processing the data. Therefore, if one has to hold on to data, if one would like to maintain a database, my suggestion is, in terms of the consent being taken, please link it to the service by saying that we will be holding your data such that you will have access to the data if you ever need reports, if you ever need your data sent to you in such a manner. Link it to a service that is being provided such that one can fall within the definition of processing and state that there was consent for the same. That is all. I think in terms of compliance, it's very difficult to say what all needs to be done at this stage. There's not a lot that we know. But what is important is your data processors, the entities which are handling your data for you, which are storing your data for you. There has to be robust contracts with them, providing for strict liability and providing for indemnities. Because presently, let us also be clear, the Act also provides that even if the data principal fails to exercise their rights under the statute, the obligation on the data fiduciary does not get waived and it does not get lessened. So the Act has a two-pronged approach. One is putting the onus on the data fiduciary to comply with the law, to ensure that he or she is in compliance with the consent, and the right on the data principal to make sure the rights are enforceable. But if the data principal does not act, data fiduciary still has to be in compliance. And which is why please make sure that the data that is being protected is protected by an entity which has the technical expertise for it. Let that entity take the liability, a strict liability to say that yes, there will be no data breach, there will be no data loss. Please maintain a log. That is one of the, I think, one of the methods that we've seen being applied everywhere globally, that there is a log being maintained for what data was added when was it visited and by who, such that all of that report can be provided to the board or the data principal the minute they ask. It is really the transparency that one can show and the best efforts that one can show which will keep it in good stead. That's about it for me. If there are any questions, I'd like to take it at this stage.
Thank you. Thank you very much, Mr. Sen. I think you've taken us through some of the complexities of the Act and the rules, tried to, interpret some of the tougher areas, especially as it relates to healthcare. And life, it seems, is going to get more complicated. Also, probably we are going to have large departments in hospitals and diagnostic centers with multiple people who would be responsible for this, because it seems the maximum fine, if one may call it, can go up to 450 crores. I mean, I guess, we'll see where that goes. And also the fact that we have tons of data, terabytes of data, which we already have with us, and and we are protecting it, we have held it. How does this law apply? It seems from what you've said, it does apply retrospectively and there's no time limit to it. And most storage of this data was kind of unconsented. It was as if we were doing a favor to our patients by holding this when we were not supposed to actually hold it, except in certain circumstances, legal cases, or under certain laws and rules like the PCPNDT Act or acts like that, where for a specified period we were supposed to hold this data. Also, it appears that we will need to store this data forever, till such time, under the processing, which I think you've explained very well. I, as a radiologist, also have been able to understand that termination is asked for or deletion is asked for by the principal, which in our case would be the patient, or the father or mother, or of the child, or even any caregiver. So I will ask you two quick questions, and then we will go to Dr. Narayan, and then to our other panelist. Um, uh, I mean, building on your insights, how should healthcare institutions interpret their responsibilities as data fiduciaries or significant data fiduciaries, given the high complex data flows between hospitals, labs, cloud platforms, intermediaries, medtech partners, doctors, and also, we are sending our data to patients, their own reports, their own discharge summaries going through WhatsApp, going through emails, which we hope and are, protected, which have firewalls in them. But how should, we see our responsibilities going forward?
So I think that's a very, very interesting question. So let me just deal with the last bit of this question to begin with, because I think it's very interesting. So a lot of data, a lot of reports are communicated to the patients by way of emails, by way of WhatsApps, for example. Now, if there is a breach in the system on, let's say, for a minute, a service provider, an instant message service provider, I don't know if that is going to be something that the data fiduciary can take responsibility for. Because otherwise, now the data world, the digital world will be meaningless if you have to ask the employee, the data principal to come and you will then transfer that data to them. Because then the whole digitization of data and the freewheeling and the free way in which the data can be transferred will go away. So I think the data fiduciary can only make sure that the IT systems that are there within the organization are robust and absolutely, they are risk free. As the minute we have that, if there is any deletion of data, if there is any transfer of data and unauthorized access of data upon transmission, that I think the fiduciary may be able to step away from by saying that is a third party's. So one could possibly, and I'm just thinking out loud, one could possibly in the consent form also state that you consent that such data will be provided through means of, say, WhatsApp or an email, the email service that you like, so that it is not my decision. Because as also I think it's important for us to remember, Dr. Mahajan, that processing also involves transmission. So me transmitting the data is through a data processor. So in that case, the email service provider, the instant message service provider may be considered to be a data processor, but I'm still the data fiduciary. So at some stage, we will have to show that this was the patient's own decision, that he is willing to take this on WhatsApp, or I'll have it on my website and give them one of the maybe the OTP system for them to download it, such that my system remains secure, and maintain that log. That log, as I've understood from a lot of people in the IT industry as well, globally, even for GDPR, when it came out in Europe and people were trying to figure out what to do with it, one of the essential things that I think people adopted was the log system, because A, the board asks for it. B, as a significant data fiduciary, you will have to have an audit done, which means, and you will have to have a data impact assessment done, which means one will have to see your existing framework, the capacity, as well as the movement. Even upon deletion of data, which again, as I mentioned in the schedule 3, may not be applicable to healthcare at this stage, even there they state once you're deleting data, you have to give a 48 hours notice to the data principal and then maintain the log for another year. So the logging and creating a log for this data and who has access to it becomes important. Now, the second aspect or the first aspect of that question of the movement of this data within the organization, within different departments, from one doctor to another, again, that becomes an important from two perspectives. One is the consent. And as we know, the consent has to be specified, but not itemized. So it's a very important distinction. What happened in the draft rules was the draft rules stated that the kind of data will be itemized and the purpose will also be itemized. Happily, the second itemization has been removed. So now what the consent form requires on the rule 3 is that the kind of data will be itemized, but the purpose will be just specified. It no longer needs to be itemized. So my suggestion again would be the kind of data we will have to specify in our consent form. Maybe have those blanks and fill it up and make sure that the person countersigns on it so that he's understood what he's giving. And the description will have to be specified in as much as that, one may have to send it to other doctors or other departments for the specific purpose of your treatment. So should you choose to withdraw the same, then consequence under 6.5 and 6.6 will apply, which means that you bear the consequence of treatment being hampered, and which the Act today states that they will have to bear the consequences of that. That is in short what I could think of.
No. I think you've answered quite a few of what most of us would have in our minds. You have touched upon consent and lawful processing. In a clinical setting where care is continuous and medical records may be needed for treatment, audits, medical legal purposes, how do you foresee consent withdrawal being interpreted under the Act, especially for sensitive health data? I mean, the patient may withdraw consent at any time. Is that true? They've given consent for something and then they withdraw it. How would that affect?
So that I think is an excellent question, and I think that's something that really the healthcare sector needs to bring up for clarity with the ministry. Because presently, and you're absolutely right, under Section 6.4, it is very clear that it states, and I'll just read it out. It says that where consent given by data principal is the basis of processing of personal data, such data principal shall have the right to withdraw her consent at any time, with the ease of doing so being comparable with the ease with which such consent was given. So one can no longer, in the consent form, state that this will be irrevocable. And in any case, under the GDPR also and under the IT rules, it wasn't really irrevocable. But one can't bind them down to a contract. One can't say, I have this data with me now for a year. There is no principle of contract which now holds them. Section 6.4 gives them the unbridled power. So I think this was intended for some of the e-commerce, for the e-services, where it makes sense, where under 6.5, it says consequences of such withdrawal will be borne by the data principal, for which the data fiduciary will not be responsible. Now, the consequences in the healthcare sector are dire. Because if you withdraw your consent, the consequence of that is you don't get the treatment. Where I would imagine Section 7F and G becomes relevant, which states, I'm just going back to my slide. Actually, I won't go to my slide, I'll just read it out. Section 7 said, F said, where it's responding to a medical emergency involving a threat to the life or immediate threat to the health of the data principal. That is where the healthcare professional may proceed even without express consent. So those are the legitimate uses, as you would recall, Dr. Mahajan, when we were reading Section 4, it said for the specified purpose, all legitimate.
Yes, you mentioned that.
Correct.
That there were exceptions to the rule.
That's right. So that exception may then have to come into play when a healthcare sector is in play and it's in question, and when consent has been withdrawn.
Thank you. Thank you for that. And now let me bring in the other two panelists. Dr. Narayan Penze first, who's the Senior Vice President, Medical Strategy and Operations for the Fortis Healthcare Group, and a dear friend of mine as well. Dr. Pense oversees clinical operations, medical governance and strategy across one of India's leading hospital networks. He brings deep insights into how large hospitals manage clinical workflows, data utilization, and digital transformation. Dr. Pense, a few words from you, and then maybe I ask a few questions. Then I go on to Ms. Rao, and then the three of you can jostle amongst yourselves.
Thank you. Thank you so much, Dr. Mahajan, sir, and excellent work by Dishampati. I think to summarize a complex act like this, which is still it's just come on us and it's still unfolding. We still need to come to terms with, what all does it encompass, and also to prepare ourselves. There is some timeline which has been given, thankfully, by the authorities for healthcare industries and others to prepare for the full scale of implementation. But I think the key points which were mentioned by Dishampati and by you, Dr. Mahajan, first is that the purpose of data collection in a clinical setting is for treating the patient. continuity of care. Today's care has become more multidisciplinary in nature. There are more partners within the hospital, outside the hospital, when we talk about continuity of care. So, does medical data and care data trump, privacy at times? I'm sure it does. Will continue to do so, but then we need to balance it with the provisions of the act and the rules which define the act more clearly. As healthcare providers, I mean, my experience comes from Fortis, which runs different hospitals across the length and breadth of the country. But I think few things which we immediately as healthcare providers need to put into place is first to create awareness and sensitize all our people about the importance of personal data. uh, Many things are old established habits or practices which may not really be required from a data collection or data sharing point of view. I think that's a logical place to begin with. And we are already doing some of these things, for example, reviewing our applications, or minimizing the access controls, etc. But it's important for first to create a complete awareness around different stakeholders in a hospital setting, right from the front office team, the call center, to the medical transcriptionist, data entry operators, nurses, doctors, which itself is a gargantuan task for big busy hospitals. So understanding the complexity, maybe creating a think tank or an implementing team within larger organizations, to put it in a simple, user-friendly manner in which operational changes can be brought in. So I'll stop here, and I'm sure the questions which follow will cover some of these parts in detail, sir.
Yeah, yeah. Dr. Pense, uh, we all know Fortis is a huge organization managing massive volumes of data from OPDs, ICUs, imaging, labs, remote monitoring, you have it all. What operational changes do you believe hospitals must prioritize to effectively implement the DPDP Act and rules, especially in areas like consent management, staff training, and handling of manual records? Even though we are becoming more and more digitized, but would consent be digital? Can we just go ahead and have people sign rather than on paper, sign electronically? Is that how you would plan, how you would advise going ahead?
Thanks for the questions. Are very relevant, very topical, because these are exactly the kind of discussions that even we are having within the organization and within the industry, actually, not only within the organization. But so there are two parts to consent, sir. One is the procedural consent, where a consent is taken from the patient for a specific treatment or a procedure which the patient is undergoing. It could be a surgery, it could be a chemotherapy, it could be dialysis, it could be something else like that. Now, for those procedural consents, our understanding is that they will continue to be physical in nature, because simply of the acceptability of the signed consent in a court of law at this point in time. It may evolve very soon, but at this point in time, it seems to be in favor of physical consents. I think the consent that we now are talking about, and where the role of the consent manager and the entire process comes in, is from a personal data protection point of view, which can start actually at the time the patient registers with the organization, rather than at the time of the patient coming in for a specific treatment. So that consent which the patient gives at the time of registration, that is the time when his or her personal data gets actually collected. What is your name, what is your address, what is your phone number, what is your email address, etc. So I think that consent management definitely needs to be strengthened. That is envisaged in the act itself, and the role of the consent manager, etc., will come into play very soon. So yes, consent needs to be the entire process needs to be revisited, particularly from the collection of personal data point of view. Would be is our approach at this point in time. We are not changing what we do with respect to procedural consents currently. The second comes to around training of the various stakeholder staff. So like I touched upon earlier, so it starts actually from the maybe the call center to the people who man our front offices and PCS teams. Patient experience, for example, is a big area today, where questions can be there around how we manage the patient's privacy. We are all flooded with spam calls, etc., despite DNDs and everything. So that definitely, the customer side of it definitely needs to be handled better by all the stakeholders. So we are planning to have an entire learning and development module around it, which can be disseminated through a learning management system, and of course handholding and grooming and training of the staff members, particularly new recruits, etc., is something that we are planning. But what most importantly we are also doing is trying to minimize the data. You go with a single source of truth. If the patient's mobile number has been collected in one application or at the time of registration, there is no need to collect this number again and again, or the patient identifiers again and again. So today, with interoperability between various applications, you can port that data from one place to another. So that is one way of minimizing repeated collection of the same data by different departments or different functions. Secondly, many times the patient identifiers are actually not required. I mean, it's just a matter of habit that everybody downloads a report from the HI, says mujhe patient ka mobile number chahiye, so that I don't have to look anywhere else, I can make a quick call if needed. But that's an abuse of the system. That's where it's just convenience which is actually determining it. There is actually no need for a patient's mobile number. Even if you have the UHID number, or whatever ID the hospital uses, that is actually enough for those with access rights to trace the mobile number if and when required. Today what happens is, it is more convenient. You download an Excel, sara data de do, address, name, father name, mother name, whatever is there. So I think those things definitely we have already started. We have
So,
sanitized some
do
of
you
the
think,
data.
Dr. Pense, you'll need to build firewalls so that only that much of data, what you think is necessary for processing, be able to be downloaded by whosoever you give the rights to?
So there are two parts to it again. One is internal data sharing, which can be managed through user access control. You have various roles which can be given. So even whether it is nurses, clinicians, administrators, etc., not everybody needs to have full access to all the data at all points in time. Secondly, many times it happens that small things like if you have an active directory, so that controls, whenever somebody is leaving the organization, is it automatically the account gets deactivated, rather than it continuing and increasing the risk. So those kind of controls can definitely be put in internally. Now when you have to share data with an external partner, I think that's where a lot of challenge comes in. And with I'm sure we'll be touching upon AI and use of data for AI purposes,
Yeah,
etc.
yeah. In fact, that's my next question. Let me ask it. Increasingly, large hospitals, large diagnostic centers, chains, they are relying on AI-based systems. There are central nursing stations, remote viewing platforms, digital imaging archives. How should healthcare providers balance innovation with the stringent obligations of the DPDP Act, particularly around accuracy, accountability, and safeguarding high risk clinical data? Are we going to make things so complicated that, a doctor in his clinic or on a round in the hospital says this is too complicated? I don't want to get into it. It's better if I don't access it because I may be liable. I mean, these are all questions that are going to come in, especially when you hear that the maximum, penalty could be 450 crores. I mean, they talk in that, but even, a few thousands. And to be held liable itself is something which is so detrimental to our whole standing in the profession.
No, very true, sir. And the medical, practice, the bedrock of medical practice is research. I mean, you research on data. That's how the entire science of medical practice has evolved. But it's time to change, and innovation now cannot come at the cost of compromised privacy for somebody. So that's where the role of consent comes into play. And if a patient explicitly says you will not use my data for any purpose other than treatment, then we can't. I mean, till now like I said, we have been used to a certain way of working because of the nature of the business, that we are in. But that is bound to change. Firstly, secondly, even when it comes to AI, and there's a lot of debate happening about responsible AI, ethics in AI, etc. So, firstly, if you need to partner with somebody, first think about, do you really need to partner? Is there a specific business need that AI is solving for you? Otherwise, many times, and we are inundated by requests for partnerships and piloting and POCs with AI, etc. First is it something which is going to be a value add for the business? Is it going to be a value add for the patient? I think that's the logical starting point. Secondly, what are the credentials of the partner that you are signing up with? Because does that partner, that vendor, does he or she have understanding of the sensitivity of the data which will be shared? How will that data be safeguarded? How long will it be retained? How will it be purged? Will there be any identifier data? Many times it is just a data dump which is taken and given to the vendor. That's a wrong practice. I mean, and that resides with the data fiduciary. Does every AI require name and phone number of the patient? Of course it doesn't. We all understand that. In fact, even in publications like clinical journals and all that, patient names, photographs, etc., were done away long time back, sir, even in print. So we also need to understand that when we partner with somebody with AI, it is our responsibility to safeguard our patients' data. Even today, forget even before DPDP came into play. So, have proper contracts, evaluate it from a data protection perspective. As far as possible, keep the data under your control. Like at Fortis, what we do is we insist all applications to be hosted on our cloud environment. Even if a vendor needs access, he comes through our firewall with exceptions and licenses which are given. Does that hamper AI? Yes, it does. It does. And many times Fortis is said that we are very slow as compared to many of the others who are fast movers. But then there is reason in approaches, the approach that we are taking, precisely because of these kind of considerations that we need to put into place. So minimize data, encrypted data, masking of data, hosting of data, and purging the data once the purpose is served. I think these are the golden rules for any AI development which happen. Forget whether it is healthcare or any other industry, sir, for that matter.
Thank you very much. You've really given great insights into practical issues and how to address them. And I'm sure, our consent forms are going to change, our way of working is going to change. And there I would request Mr. Sen to really help us going forward. You and others of your ilk would certainly be required to help us overcome these hurdles. And now to what Dr. Pense has been talking about, research, development, AI, and we have one of the best here, Ansuya Mohan Rao, who is a senior leader at Philips Innovation Campus in Bengaluru, where she leads clinical partnerships for the global clinical science and co-creation of organization within the magnetic resonance business unit. Over the years, she has led creation of innovative software platform solutions and clinical products. Uh, and let me tell you, there are nearly 2,000 or more scientists, engineers who work in this huge campus that Philips Innovation has in Bengaluru. So, carrying on from where Dr. Pense left, and Mr. Sen has said that somehow the Act is silent on de-identified data, though it does make exceptions for research and appropriate use or legitimate use, with being a little, not perfect in defining what is legitimate use, whether that's good for us or bad for us as healthcare providers, researchers, and developers. That only time will tell. Maybe courts will interpret going forward what is legitimate use, why de-identified data is not part of what. I mean, this is a word that's been around for years now. So why that got left out? Is it on purpose? That is all that we'll come to know now in the months and years to come. But software as a medical device is becoming central to diagnostics, whether in AI-driven imaging, remote cardiac monitoring, or automated clinical decision support systems. As SAMD increasingly relies on continuous data inputs, analytics, and cloud connectivity, can you please share a few operational challenges which the industry is likely to face going forward, especially with the obligations that come from implementation of the DPDP Act? What is your feeling? Because you're right in the thick of things as far as research and innovation and product development is concerned, and you're making in India for the world the buzzword which our Prime Minister talks about. Will this somehow hamper these efforts?
So, thank you very much for the opportunity, Dr. Mahajan, and other panelists. It's great to be part of this. Um, I wanted to first start with a very quick reflection based on what Mr. Tishampati Sen shared. Um, First and foremost, I'm glad that um, we are putting the focus back on the individual and the patient. Yeah, so that is one important development. And for us in Philips, in line with our strategy of people and patient-centric innovation, this is something that is super important because Dr. Pense brought in the aspect of AI. AI is definitely going to revolutionize healthcare. We are seeing it. On the same token, it also has to come with a lot of responsibility across the entire ecosystem. So, Dr. Mahajan, you spoke about the operational challenges and requested me to dwell into some of those. So, one of the first things that I would like to bring is on the aspect of anonymization. Yeah. So, the DPDP Act emphasizes data minimization and limiting the use of data to the strict purpose, right? So, hence, it becomes all the more important that we operationalize anonymization in a way that is consistent across hospitals, the imaging centers, as well as vendors, vendors like us. So, I definitely think that there is a need for a national guideline for de-identification, anonymization of the imaging data. Yeah, especially for AI development and research. So that is one aspect. And in line with that, I think it's also important to bring in clarity whether the vendors, the SAMD vendors, will be supplying built-in anonymization tools, or will hospitals be expected to handle it upstream? By upstream, what I mean is the anonymization done earlier in the hospital's workflow before the data actually reaches the vendor's application. So that is one aspect of anonymization that I think is going to be very, very important. And it needs to be addressed to make sure that we have some standardized protocols. That is one dimension. The second dimension, and this is something that Mr. Sen also alluded to later, is about the data processing agreements themselves, right? For us as a vendor, as an healthcare innovation company, for us it's crucial as part of our strategy that we work with clinical partners. Yeah, and uh, and given that data is the new platinum or the gold, it becomes all the more imperative that when
I
we
think those
work,
words have been, very detrimental
yeah,
for, because somehow, people tend to believe that hospitals have gold and platinum sitting in their computers, and God knows what kind of profits they are going to make out of that without realizing. Of course, privacy and consent, all that is important.
Yeah.
But if they start thinking we have platinum sitting in the hospitals, then they will think that treatment should be given free of cost.
So in as much as it is seen in that way, I think the need of the hour is also to see how can we standardize some of these data processing agreements between hospitals and vendors so that it is used in the right way for the benefit of the patients and for the overall clinical community and the clinical practice. Because from my practical experience, what I have observed is that the discussion around the processing agreements goes on for months together. It takes at least an average of around 6 months to close to a year to get that finalized. Whereas here we are looking at getting the best in class applications out for the benefit of the patients. So, are we really doing justice to that? Is the question. So I think I would like to summarize it with two aspects, Doctor. One is making sure that we have some standardized anonymization protocols. That's going to be very important. And the second one is we need some harmonization when it comes to the agreement templates itself, so that that should not become the bottleneck for us to bring in our innovation.
I think
So
that's very well said. As I understand, you alluded to, anonymization happening before or at a later stage. I think currently, as things stand, especially for development for AI tools,
yeah,
AI algorithms, it is done prior. So when
indeed.
they go up to cloud for analysis, it is all de-identified and then sent back, and then the identification happens in the packs or the computers of the hospital. That is how things are happening already, and that would be in conformity with the privacy laws, even though this act appears and the rules appear to be silent on de-identification. So I think on that stage we are absolutely clear that we are following whatever are global norms in this country. Now, just one more question. The government of India is incentivizing R&D, especially in medtech, and we want to be a medtech powerhouse going forward. Please help us understand from a R&D perspective how the DPDP Act would affect global R&D projects running out of India. You know, in India, make in India for the world. Will there be any change? Do you envisage any change in the way you work, in the way you interact with those outside, considering that it's all software basically that we are building here?
Thank you for that question. And I think it's an important one. Um, Given that we are part of this global R&D organization, and you've also seen our campus in Bengaluru. Um, so the clinical applications or the solutions that we develop are indeed for the world. They are designed and developed across multiple sites. Yeah. So we could have solutions for a large release come out of India. It could come out from the Netherlands, US, or Germany. So this means that we would need to have the ability to seamlessly share data across borders. Yeah.
Sure.
And all the more in a world where we want to leverage AI and use it for the best purpose, we need to have this ability to share data. So I particularly think that the impact of DPDP in this scenario needs to be well understood. Yeah. So that is one part. And the second part is we would definitely need to conduct multi-center studies in India, because we definitely want to have more and more solutions being built for India. It also means that in such a case, if we have to work with multiple partners across India, we would need harmonization, standardization of consent, as well as all of the infrastructure and other obligations that are arising from DPDP. So that's the second part. About multi-center collaborations across India itself. Then the third one that I wanted to highlight is, for us, we have already been on a journey where we need to adhere to and comply to the GDPR. So specifically in this case, with all of the emerging DPDP rules, regulations, we would need to assess the differences between both of those. And specifically from a development standpoint, we would need to comply to both, since we have R&D locations across different geographies. That is from a development standpoint. We need to adhere to both. And also from a business standpoint, we also need to adhere to both of these, because yes, it is not just about compliance, it's also a ticket to play. We definitely would not be able to sell if we do not adhere to both. So these are the three aspects that I would like to bring forth, Doctor.
So one quick question. Do you think these rules and law have brought us at par to what was existing in other parts of the world, especially in Europe? Or are we ahead of our times? Are we ahead of other parts of the world in actually bringing out these rules, which are very, very important? I mean, data privacy, consent, all these things are very important. Are we showing the direction to the world?
I definitely think so, because in many cases, Doctor, I've observed that I will be very open here. We hear comments, outside of, when I travel across sites, I do hear that, okay, maybe it is easy to get data from India. No, that is not the case. We are in an evolving world, and I think DPDP is a very, very formidable step in that direction. Our patients are who are part of our ecosystem need to be protected,
Very
just
well,
like just
very
like
well
any
said.
other patient across the globe. So
Absolutely.
it is definitely a very formidable, a positive step in that direction.
So, being a powerhouse in IT, I think it's appropriate that we are taking the lead in this, and of course there would be challenges, there would be pain, there would be a lot of help we would need from legal luminaries like Mr. Sen and others from there. But the fact that we have to actually fall in line is a given. And now, before I let the three of you talk amongst yourselves and ask questions and give answers, we have some questions on the chat box. And the first one is from Sajan Bhan, who says longitudinal research is part of many fields, including healthcare. If it is not defined, then I hope it will not be a point of contention between the entity, the person, and the government. Mr. Sen, can I have you take that?
So I think it's a very relevant question. And as I said at the beginning, I think it's more important to ask these questions right now than to look for answers therein, because it's a very, very valid question. I don't know how Rule 16 will be construed. My only thought in this is, when we look at GDPR, because I think Ms. Rao also talked about GDPR at one point, processing was defined as being different from research. But there was scientific research stated. In Rule 16 in our rules, and I'll just read it out again, because that's the only place where any form of research is being identified and it's being kept outside the Act. It says that the provisions of the Act shall not apply to the processing of personal data necessary for research, archiving, or statistical purposes if it is carried out in accordance with standards specified. So again, for me, any sort of research seems to be standing out, but it cannot be a carte blanche. I cannot, I cannot read this rule to mean that the minute that you are claimed to be, conducting some sort of research, you will have the ability to stand away from the act. So I feel that research, when it is also taken with the consent, now again, this brings me to the second point. Consent for processing presently in the way the act works is for the purposes of a service being provided to the individual, being provided to the data principal. So therefore, simply to say that I will host your data for the purposes of research may not mean consent within the meaning of Rule 3, Section 5, and Section 6, because it has nothing to do with the service that is going to be provided. In fact, may I just read that portion? Because I found it very interesting when I was reading it a few days back in terms of Section 5. Just 1 minute. I'm just going to read this portion out. Sorry, just give me 1 minute. I'll read Section 7A. Yes, it says, for data fiduciary may process personal data for the specified purpose for which the data principal has voluntarily provided her personal data to the data fiduciary. That's one aspect of it. And under 6, we see that agreement shall signify an agreement for the processing of her personal data for the specified purpose and be limited to such personal data as is necessary for such specified purpose. Therefore, just the fact that you want to say that we want to take this data for research may not be good enough. It will have to be linked to research and other services being provided, and then maybe define research very clearly in order to fall in the bracket of Rule 16. But presently, in answer to that question, I don't think there's a clear answer in terms of the Act or the rules. Yes, I think the Act under Rule 16 seems to be signifying that research stands apart, just as in GDPR. But what those provisions are for research it is not provided, because GDPR provided for a research paradigm under Article 89, which stated that if you're conducting research, and this is the criteria that one must keep in mind, that is missing in the Act. Once that is there, I think one will understand what kind of research therefore falls out and what kind of research will be applicable in terms of the Act.
One quick question. Does the healthcare provider need to keep this digital data for perpetuity? Is there any, time beyond which, because, storage of data also costs money. It's also the responsibility of keeping it. So can we put in our consent form where the patient says that, after 1 year, 3 years, 5 years, I give you my consent to delete my data? Can that be done right in the beginning? Unless, and she may say that unless I write to you or send you information to the contrary, can that be done?
So it's again one of those gray areas in the Act, and here's why. First, so the stated intent and objective of the Act, as I think Mr. Rao also mentioned at one point, is to give control back to the data principal. It was also to minimize data, as Dr. Pense stated, that you must minimize the amount of data being taken, and a finality to it, that after a certain point, data will have to be removed. You cannot be in custody of someone else's data till perpetuity. So the stated object of the Act is a finality to the data being in the control of data fiduciary. However, the problem is, and again, I may be, committing the, sin of being hyper technical, but because if the word deletion was not there in the word processing, I would state that deletion would not require consent as soon as the specified purpose is over. But because the word deletion is there in the definition of processing, my suggestion, my advice would be to err on the side of caution and do exactly what you stated, Dr. Mahajan, to state right in the beginning that once you have finished treatment with us, once you have finished taking our service, if we don't hear back from you in, say, a matter of 6 months, or if you tell us, we will be deleting your data and we have consent for the same. This is, of course, subject to whatever other laws and regulations may be applicable upon us. This, for example, if I may step away from healthcare and look at myself as an e-commerce industry, I may not be able to do that because Schedule 3 there prescribes 3 years I will hold it. After that, I will deem that service is no longer done. Now, a question I put to myself is, as this is a higher standard, this is a standard which says that an e-commerce service provider cannot hold on to data after 3 years, if there is no contact from the data principal, assuming therefore, or rather deeming therefore, that the service has ended. Can a data fiduciary in an e-commerce situation not step up and say, I'm giving myself a tighter standard? Since the object is to delete data and not remain in my possession, I'm saying this will be 1 year. After 1 year, I will deem it to be no longer in use and remove it. That is an interesting discussion at that time as to whether it's in the interest of the data principal that it be removed, or in the interest of the data principal that it continues for the period for which the law prescribes. But in answer to the question, as far as healthcare is concerned, I certainly think the consent form should say right in the beginning, we will be processing for these reasons. Once these reasons are over and we don't hear back from you, no further usage of the data is coming up for the above mentioned specified reasons, we will be deleting the same within a period of 6 months. We will provide you a 24 hours notice, because the Act under Schedule 3 does require a 48 hours notice. So we say we provide you 48 hours notice, but we take it that we have consent to delete. I think that is an important aspect.
That I think is very important. And there's a similar question from Jitendra. As per the Act, once data from certain studies has been archived by healthcare services with appropriate consent, can a subject subsequently request that their data be erased? I think the answer would be yes, but please elaborate on that.
No, certainly. Answer is yes. Even in terms of the existing law prior to the DP Act, the answer has always been yes. Even under the IT rules, they could withdraw their consent. So yes. Secondly, in terms of Section 5(2) of this Act, one is required to now put the consent and give them the option to withdraw for data taken prior to the initiation of this Act. So certainly they have the ability to withdraw. The consequence of that, whether it has reached the stage where it's public domain or not, one will have to see. But the short answer is they certainly have the right to withdraw, because it is acting retroactively with
A
reasonable
follow-up to
practical as
this,
far as
we have the government already bringing in ABDM, the Ayushman Bharat Digital Health Mission, where in fact over the next few months and years, all medical entities have to join that ABDM, digitize everything, send it on cloud so that there's data transportability, there's data, of course, the patient will have the password, and so whether a scan done in Fortis, in Gurgaon, and then someone goes to Bengaluru, they should be able to, download and do all of that. And there is this scenario where a patient has said, delete my data. And now this data is on the ABDM. I mean, this is hypothetical as of now. And the patient says delete, but it's there on cloud, whichever cloud. We are not even sure which cloud it will be going forward. And it's there on the cloud. How will we have to build systems so that not only are we deleting it in-house, but also outside, or maybe all this data would be on a government-controlled cloud? Hypothetical, but what would your suggestion be?
So I think that's a really, really interesting setup, because to me, the minute I give my data to Fortis, for example, and I think Dr. Pense put it very well when he said, or I think Mr. Rao also, when they said that innovation in healthcare cannot any longer be at the risk of private rights or data rights. And I think that's the most important aspect, and I think that's the philosophy which this act kind of brings home, which is why it's an important act. Now, if I'm giving my data to Fortis, and Fortis is obligated in a hypothetical scenario to put up this data with a central organization, it still has to be, sorry, when I mean central organization, an organization under the central government or under any arm of the government, it still cannot mean that my private personal data has become public. That cannot be the intent. I cannot foresee, even in that scenario, for a situation where my personal data becomes public for anybody to access and see. So
No, that's not the case. This is going to be a cloud probably created by the government, or maybe it stays inside but connected to a architecture which the government has built. But of course, all the checks and balances, the firewalls, the privacy will all be maintained. It's not that my data can be viewed by someone else without my consent.
I understand. So if I'm in Bangalore and my data is with Fortis in Gurgaon, I don't need to worry about coming back to Gurgaon and accessing it. I have the ability to access it in Bangalore, which means
Absolutely.
that therefore that is a systems provided where there's an interface between the IT of Fortis and an IT system structure provided by the government or by an body authorized by the government, where the interface and whose liability begins where and ends where depends on where the interface is gone. Maybe that's a technical argument. But as far as the healthcare provider is concerned, he will have to know that I am being able to host this information on the cloud based on the consent provided to me by the data principal. If the data principal removes or withdraws her consent, that information needs to come off the cloud. And if the only person getting affected is the data principal, then that's the consequence that they have to follow. An important question came up, I mean, prior to this, and I just found the section. I'll just kind of, I think, dovetail into that also. So section 8.3 states that where personal data processed by a data fiduciary is likely to be used to make a decision that affects a data principal or disclosed to another data fiduciary. So here, for example, if there is inter-hospital sharing of data, or there is a sharing of data between a service provider like an AI operated entity and a hospital, there is a contemplation of that scenario under section 8.3 of the act, which says that both of them will be considered data fiduciary. And it also goes on to say that the data fiduciary providing such data shall ensure its completeness, accuracy, and consistency. So it is contemplated by the Act. I don't think it is worded very well, and I don't think it is worded in a complete manner. I think industry practice and industry comments will have to have it refined by way of notifications, by way of circulars. But it is contemplated, a sharing of data. And I certainly feel that the consent is supreme, subject to the exceptions under Section 7.
Thank you. Thank you for that. Now, there's Anupriya Gogna, who's asked if only anonymized data is stored and shared with a third party, is consent from the data principal required?
Uh, So yes, I think it would be required to the extent that one says we would have to anonymize the data, because again, the processing is the is the biggest is the widest definition that we have in the act, and it could mean anything, including anonymizing it. So any sort of processing, any sort of treatment of the data comes within the definition of processing it. So the way I see it is that the healthcare provider will, or the data fiduciary rather, sticking to the terms in the Act, will have to take consent for anonymizing the data. Once anonymized, the data or that anonymized data, according to me, falls outside the definition of personal data, because personal data is such data which you can identify the person individual with. If the data is anonymized to the point that you can no longer, in that pool of data, identify which data belong to which individual, the withdrawal of her consent would only mean deletion of her data as identifiable to her from your records or from your system. But I don't think it can affect the anonymized data, because it's impossible to pinpoint which of those data will have to be.
Of
And if you
course, there's the exception, in radiology. I mean, we stand apart because you do a head CT or do a head MRI. These are all 3D, and you can reconstruct the face. And with that, there's already AI tools available which can tell you the address, the phone number, the Aadhaar card number, everything. So anyway, this is just as a side, but just to highlight how tough it is for us radiologists
no,
and for
Dr. Maja,
imaging
I must say one
departments
thing.
to actually hold on to privacy. But I'm sure the government doesn't know about this, and I'm sure everyone who's on this webinar will not tell them.
But Dr.
Let me
Majan,
take up,
can I
yeah,
make one
please.
statement on a lighter side? It's really fascinating for me. When I was reading the Act and I was considering the sections, I was always looking at it from the data fiduciary's perspective. And I was looking at it to see how can data fiduciary's interests be, kind of looked after in a provision in a statute which looks to protect the data principle. And it's fascinating for me that I heard you, I heard Dr. Pense and Ms. Rao, and all three of you who are considered to be the data fiduciary, all of you spoke very highly about how it is well and it's good time for us to start looking at the data sensitivity of the data principle, and you've looked at it completely from a different perspective, which I think is wonderful to see. That
Even though we want to protect our organizations, but I can tell you, are very cognizant of data privacy. We don't even tell people who came to a hospital. I mean, it's for some third party or for the person themselves or their family to tell. That is how conscious we are of, this one aspect. That even to the tune of saying, if someone were to ask me, did so and so come to this hospital? I'll say, I don't know. You have to find out. So now, to follow up to all of this is Avnish, who writes very well. Best is not to collect any data at all. I wish that were possible.
That really is not
But in
possible,
today's
sir.
world,
At least not in a hospital setting where we do need to collect all kinds of data simply to be able to give care to our patients. So unfortunately, that's not an option.
Avnish, कर नहीं पाएंगे भाई.
So just one input from my
Yes,
side
please,
at this
Dr. Pense.
stage. In the sense of anonymization now, also that we need to understand that there are various types of anonymization and levels of anonymization, pseudo anonymization, true anonymization, etc. So I think those will also have to be understood and defined, because we discussed about AI and data being completely anonymized and not retrievable to derive the information of an individual. Well, if it is to that level of anonymization, then of course, things would be different. But one needs to understand that there is a spectrum of anonymization techniques. So even that technical know-how will also have to be developed, amongst the healthcare, particularly those who are sharing data with third parties. Yeah,
Thank
just wanted to
you.
add that bit, sir.
Thank you. We have Navneet who is asked, how should one, and maybe Dr. Pense or Dr. Rao could take this up, how should one go about data mapping and inventory in the hospital and head tech space?
I think Ms. Rao, if you would like to take that question, because it deals with health tech directly, and then maybe I can come in.
Sure.
Yeah, I think it's a very important point that Navneet has brought in. From our standpoint, we make it a point to have what are referred to as clinical data lakes, yeah, where there is encryption, as well as, of course, all the data that comes into the data lake has gone through the consenting process. So we only receive that kind of data. And apart from the encryption, we also have the ability to trace the data. Yeah, trace the data and also understand what is the data provenance. So all of those aspects is something that needs to be taken care of in our data lakes. And it's also important to keep in mind that the data in these data lakes could be used for AI or even non-AI enabled applications. So a rigorous way of making sure that we set up the data lakes, maintain the data lakes, and comply with all of these regulations is going to be very important. And that's how we operate within our company.
Dr. Pense.
Yeah, I'll talk a little bit about the operational side of this, sir. And
Oh,
we
that's very
realized it
important.
we realized it the hard way, to be honest. There are always a bunch of applications or softwares which come with devices. For example, I buy an endoscopy, machine. There's a software which comes. I buy a MRI. There is a software which comes with that. Now, many times what happens is that they don't really come under the ambit of the, IT audits, etc., because they typically are, biomedical devices, etc., and sometimes they are required. The vendor needs access, the OEM needs access to do quality assurance studies from the back end, etc. Now, when we got one of our audits done, we said we want to include these also in the ambit of our IT audits. And to be honest, we were really surprised at the lack of controls around these. Obviously, this is a gray area, but I'm just highlighting one area, for example, which could be a potential breach. We haven't talked about breach too much in the course of today's discussion, but that's very important aspect of the DPDP Act also. Now, what we realized was that the operating systems of these devices, the controls which were there were actually people on the OEM side who had actually left the organization and gone away years ago, but they still had continued access. And you are a radiologist, sir, in the MRI machine or CT machine, all kind of metadata is available.
Sure.
Patient ka ID, patient ka naam, age, there is a bunch of data, and that can be derived, like you said, to get the entire the profile created again. So we need to work with our industry partners around these aspects also. We have now started building in the clause of digital data protection into all our contracts that we sign, whether it is with device manufacturers, whether it is with software applications, etc. So it's again just an operational aspect that I wanted to bring out for the benefit of all the participants. Many times it is the small things which actually create problems later on. So having an understanding of where all things can go wrong, where all data is being collected and how to handle it is, I believe, the first and most important starting point for everybody who is in the healthcare provision space.
Yes, Dr. Rao.
Yeah, I just wanted to chime in with one aspect on the topic of inventory. Given that our industry is heavily regulated for all the right reasons, keeping this inventory, maintaining it to the highest level is super important. Um, at any point, if we were to have an AI-enabled application that has training data, the model requires training data. At any point, we need to be able to furnish the data that was used to train that AI model. So that also
That's not
becomes
happening at the present point of time. In fact, the lament of users and of buyers of AI is that you don't know where it was developed, what data was used, how much data was used. It's all shrouded in absolutely opaque terms. And I mean, 99% of AI developers don't give you anything about that. And now with generative AI,
exactly.
you can actually make more out of 100, you can make 1,000 or whatever. So it's becoming more and more complex, and
Yes,
no one wants to let you know. Under this act, I don't know how that would be, but I think there is concern that you don't know where and whose data has been used in making AI algorithms, which are valued at millions, hundreds of millions of dollars. So I think you bring out a very, very
yeah.
important point.
Sir, on a lighter note, in some of our internal discussions, we refer to it as Adi intelligence or Adhuri intelligence sometimes because we really don't know where it is getting built from.
That's true. We have just about a minute left. Shilpa, are you there?
Yes, sir. So there are
Do you
about
think we still have quite a lot of people who are still joined? Can we extend it by 5 minutes or so? There are
sure.
some questions which need to be taken up.
Yes, and there are questions in the Q&A section also. 35 questions over there as well. So
Yeah, I'm
whatever we
looking at
can
the
take.
chat.
Yes. Okay.
Yeah. So
Sure.
Ravi Kumar Reddy asks, under the Deep Act, does a patient have the right to refuse sharing their personal data or demographic information such as contact details? He says, मैं नहीं बताता मैं कहाँ से आया हूँ.
I mean, it's silent, but yes, I guess he can choose to withhold some part of his data if he wants to. I don't know. So actually, the Act does provide for usage of that data, which is essential for provision of service. So therefore, it gives an illustration also. For example, saying that if you are, buying a good, where you stay may be relevant. Your phone, or something else. I can't find the illustration right now, but the illustration is very clear in saying that that data which is relevant for the provision of the service may be asked for. What is unrelated to the provision of the service may not be asked for. For example, you getting a commodity may not they may not need to know your Aadhaar number. If you're getting something delivered home. So by that same logic, I would imagine that whatever is relevant for the treatment to be done, for the service to be provided, the healthcare, the data fiduciary may ask for it. I think Dr. Pense did talk about it when he was saying that within Fortis, they are now doing the training to minimize data, the kind of data that you will ask for. Not all the data is needed. And I think that kind of answers this question that the Act contemplates relevant data to be asked for, which is why the consent form asks for specifies itemized data A, B, C, and D that we will be asking for, and this is the purpose. If you think your data is not relevant for the purpose, I guess the data principal can withhold his consent for that and then require the data fiduciary to change the consent mechanism.
And then a follow-up question from Ravi is, can a patient request deletion of their personal data from the HIS or application under the Act? If so, how should healthcare providers handle such requests while ensuring continuum of care?
So that is provided for under Section 8.7, which I read a little bit. I'll just go back to that. It says that if there is a data, someone is asking for the data to be deleted, then the data fiduciary is responsible to delete the data. And then the consequence of that. So again, there are two things. As we've seen before, it says that data can be deleted. And if you can continue to provide the service, it's just the data is gone. For example, if you're in the e-commerce setup again, if you're buying a certain bag from somewhere and once the deal has gone through and you ask for your data to be deleted, they may delete your details from their depository, but the delivery can still happen. But if, for example, the provision of a service is now impacted because your data is deleted, then you bear the consequence of it, which means that the service cannot be provided.
There's also interesting follow-up. If the data is deleted by the healthcare provider as mentioned in the consent form, should its anonymized version with a third party also be deleted? See, I took consent that I can use your anonymized data, say I can give it to Philips to make some new tool. And now the principal says that delete my data. Would it need to be deleted there as well, where it's anonymized?
Yes, I think, again, going back to the levels of anonymization, which I think Dr. Mahajan, you mentioned and Dr. Pense also mentioned, if it can be identified, if you can trace that data to belong to the data principal, I think the black letter of the law is yes, it needs to be deleted. Because the point is you have shared that information presumably because he gave consent to that data being shared with another data fiduciary. Now that he's withdrawing the consent, he's withdrawing it for the entire chain or for the entire processing. And transmission of data is also processing. So by that logic, whatever can be identified, whatever can be traced back to that data principal needs to be deleted.
So in a sense, what you're saying is that the de-identification while sharing data for maybe research, product development should be of such a level that later you are not able to identify at all.
Absolutely. That's the only way I think one can get away from this at-will whimsical withdrawal of consent, even if I put it like that.
Okay, another follow-up from Hem Gupta, who asked, the patient has given consent to delete her data after a few months or after a year, and later on court of law asks for that records for any medical legal case. What will the hospital do then?
So I think that in a world where we are in today, suppose when DP Act wasn't in play, whatever the standard of care is, for example, if you're required to maintain data, you'll have to maintain.
Sham, let me clarify further. This is a case where I don't know that this will become a medical legal case. Patient comes to me, I give treatment, patient goes away. After 6 months, the patient says, delete my data. I delete it, but he's already gone to another place and there's a medical legal case. Now from there, many years, I mean, this happens 10 years later, 15 years later, you get a summons from a court saying, I have to go to court on the 15th, where it's 2009. case where they say now you come and you don't know anything about the case. We don't have 16-year-old records with us, and that too, we don't even know whether it was a X-ray or a CT or a MRI. Then what do you do?
So I think once the data has asked to be deleted, presently the Act does not give a opportunity for the data fiduciary to ask why. It is really the data is asked to be deleted, you delete it. Now, if it is required by a court of law, and if there was no and if there was no injunction on you, there was no direction upon you, you cannot be legally obligated to provide data, especially when there is a statutory direction upon us, upon you to delete the data when they ask for it to be deleted. The only thing I'd point out here is Rule 8 of the data of the DP rules, which strictly speaking doesn't apply to us, to the healthcare sector as of date, because Rule 1, and I'll just read one line and I'll go to Rule 3. It says a data fiduciary who is of such class and is processing personal data as specified in third schedule. And third schedule deals with e-commerce, etc., does not deal with healthcare. Therefore, we are not such class of persons to who Rule 8 should apply. But I just like to read Rule 3, which says what would happen upon deletion. It says, without prejudice to subrules 1 and 2, a data fiduciary shall retain, in respect of any processing of personal data undertaken by it or on its behalf by a data processor, such personal data, associated traffic data, and other logs of the processing for a minimum period of 1 year from the date of such processing for the purposes as specified in the 7th schedule, after which data fiduciary shall cause such personal logs and data to be erased. And 7th schedule, if I go that far, is just 1 minute. It deals with when the state can ask for such information in terms of income tax, in terms of other issues. So, taking a leaf from this, although there is no obligation on us, Rule 8 does not apply to the healthcare sector as on date. One would imagine once you've been asked to delete it, you maintain the logs, and that's about it. I still think it would be erring for us, for the healthcare provider, to hold on to any bit of the data when there is no obligation or right to do so in terms of the statute once the data principal has said delete my data. It is better to err on that side than to tell the court I still have a copy. Then it'll be
Okay,
a problem.
okay. That's very well put. What about exemptions? Prerna is asking, under Section 17 of the DPDP Act, how does it figure against general exemptions?
So, Section 7, which is the general exceptions, provides for when processing can be done in those scenarios, like we've discussed, healthcare, someone's life needs to be safe, so on and so forth. That's a different situation. 17 is dealing with situations such as when a court is asking for it, when there has to be preventive detention, when, for example, if I look at A, it is for enforcement of a legal right or a claim. B, the processing is done by any court or tribunal which is entrusted by law to perform any judicial or quasi-judicial function. For example, in a situation where the board, data protection board, has to be involved for the protection of someone's right, that is where they may take the data. So, for example, as the data principal, I may put up a complaint which has gone in digital form. That digital data has gone to the data protection board. They can process it for the enforcement of the rights of the data principal. That is the exception, that is the standard of exception provided in Section 17. That is when the state or the government or the any authority, judicial authority, has to exercise its sovereign function. In that scenario, data processing can happen without consent. It's slightly different. It's not in the realm of commerce.
Raghavendra asks a question where he says for high volume modalities like X-ray and ultrasound, the industry standard has always been implied consent. The patient walking in is the consent. Under this act, if we continue this practice, we will be non-compliant because we are storing the digital data. Do we now need to introduce a data privacy signature for every single X-ray patient, or can this fall under legitimate use for providing medical care? Having said this, we at Mahajan Imaging and Labs, since about 2010, the last 15 years, thanks to Mr. Sen who advises us, have been getting consent for every X-ray, every ultrasound, every CT, everything. Even when we take blood, whatever. Even though I agree there may be implied consent, but then it's a very gray area, a tenuous area. So, what do you think, Tishampati?
So for me, this now question is no longer gray because it is the implied consent is out. There is an express consent that is required. And may I say something? Section 6 requires consent to be free, specific, informed. But more importantly, Section 5 puts an obligation on the data fiduciary to first put him to notice. So it's not an so the implicit nature of consent is out because the notice will specifically provide what information we are going to be taking from you and for what purpose. So in the scene of situation of a vanilla X-ray, that notice or a small paragraph would say that you've come in for an X-ray. We would be taking your X-ray that will enter into our IT system, which we will provide a copy to you for the purposes of the X-ray that you've come for, and we may delete the same after 6 months. But it will still have to. Section 5 requires you to give that notice to him, based on which he'll give a consent. So the implicit nature of consent is certainly out, and that I think is a big paradigm shift in terms of the DP Act.
Thank you. Thank you very much. Anything from doctors Pense and Rao?
So just one, I think a lot of questions here have, rightfully focused on what is going to be the impact on medical records and medical consents, because the retention period for a routine inpatient medical record is not very clearly defined. I mean, some acts do define, like you mentioned, PCP and DT or the Transplantation of Human Organs Act, etc. But what is the defined retention period for a routine IP admission is not very clearly defined. There are many notifications, and health being a state subject also kind of adds its own complexity. But I think the confusion is, let's say I get an X-ray done at Mahajan Imaging, and tomorrow I come and say, delete my data. That does not mean that you're bound to delete the X-ray also, because as per let's say the code of medical ethics, etc., you are bound to keep the medical records for a certain period of time. It could be consultation, it could be X-ray, it could be anything else. Now the consent which is given by the patient under DPDP is for removal of personal data. It does not mean that the medical record also has to be erased completely from your memory, because you are required to retain medical records for a certain period of time. Now, how to balance it out with the phraseology of the consent so that we comply to the DPDP Act also, and at the same time we inform the patient completely about the data retention policies. That's going to be a slightly difficult but very important aspect of implementation, sir.
Can you clarify a bit more on this,
So,
Tishampati?
right.
Because Dr. Pense raises a very important point, that is data only personal data? Is his clinical record, her clinical record, or the X-ray or the CT or the blood reports, are they not personal data, or will they also fall under the ambit of personal data under this act?
Right. I
We
think
can
it's
take the example of a medical legal case X-ray, for example, sir, just for Tishampati to probably make it a little more, linear for him.
No, so I'll tell you. So I think that's a very good question, and that is where the ambiguity in the act really shows itself. There is a simple answer to it and a slightly complicated one. So just bear with me. First of all, I think it's very important to understand the definition of data. Again, it is very wide. It is not linear. It is actually not simply worded. So first of all, I think one will have to err on the side of caution and be conservative in their reading of the act. That's at least certainly how we lawyers are trained to do. We have to be paranoid in our reading. So in our reading, data is right now means a representation of information, which is as wide as that phrase can be. Facts, concepts, opinions, or instructions in a manner suitable for communication, which according to me means anything and everything under the sun becomes data. And personal data is that data which you can identify the individual with. So, frankly, I don't see how a blood report or X-ray, etc., will not fall within the definition of personal data and a medical record falls outside the definition. But to answer your question, Dr. Pense, I think happily the legislature has considered this in section 6.6, where it says that once data where consent has been withdrawn, it states that the data fiduciary shall, within reasonable time. So it doesn't say immediately. That's one interesting aspect of this clause. It's not like there's a click of the button and says, I withdraw and you have to delete it. It says shall within a reasonable time seize and cause its data processors to cease processing the personal data of such data principal unless such processing without her consent is required or authorized under the provisions of this act or the rules made thereunder or any other law for the time being in force in India. So happily, this act is not in derogation of other laws, but I think it is in conjunction with it. So if there is an overarching specific legal obligation upon you to maintain that record, that section 6.6 provides for and protects.
Yeah, very true. So I think, let's say, the Code of Medical Ethics or the Transplantation Act, etc., are very prescriptive, and they give a retention period which is defined by the rules that you have to keep the record for X number of years. But a routine inpatient admission in a hospital, unfortunately, it's not very clearly defined. It does not come under the ambit of any one single act. So it's going to be a challenge for hospitals, particularly in dealing with inpatient records. I mean, there are some court judgments. For example, on one of the judgments, it is that how long do you keep a pediatric admission case record, which is till the time the child, attains adulthood and 3 years thereafter. There is no act or rule which has defined that, but this is a standard practice across, hospitals. Now, if somebody says, is there an act which determines this? If one reads, verbatim what you just read out, it becomes a challenge for hospitals. But
So,
these
Dr.
are,
I'll come
yeah.
in very quickly because you're making a fantastic point. The language here does not say for any act or for any statute. It says for the law for the time being in force. So even a judicial precedent will take up the space of law.
Reconsider.
Yeah.
Okay, great. I think that that's really helpful
That
in
clarifies.
understanding.
I think these questions are going to go on and on. We are already 17 minutes over our time, and it was a 2 hour time that we had kept, which makes me think, Shilpa, that probably we can take up, going forward in the weeks to come, every aspect which may, consent, deletion, whatever the case may be. So, because the interest is tremendous, I've never seen anyone joining a webinar and we are having 330 people join. And even now we have 187 who are there 18 minutes beyond this. And this is very, very important. It's going to change the way we work in hospitals. It's going to change the way we train our people. It's going to change the way we store data, exchange data, share data. And so I will take up this final question, which is from Abhishek Kumar. What are your observations on data residency aspect of collected PI data? Does government mandate to store data in India only? His take, Abhishek's take is that we can store in India, that we can store data anywhere in the world, but we need a mechanism that we can restrict certain data flowing cross borders when government or board obliges you to do so. Can you take this up and explain?
I'm not sure I fully understand what the phrase residency of
No,
PI.
he's saying that, can this data be stored in, cloud in the US or in Australia or in Singapore or somewhere else? I'm sure there's some law because they don't want anything crossing borders.
Correct. So Rule 15, so again, this is something that I haven't really examined, I must candidly confess, but I did look at Rule 15, which says that any personal data processed by a data fiduciary may be transferred outside the territory of India, subject to the restriction that the data fiduciary shall meet such requirements as the central government may, by general or special order, specify in respect of making such personal data. So, I mean, in other provisions of the Act and the rules, there is enough ability for the central government to specify certain type of data which shall not travel. For example, one to do with sovereignty of the country, public order, and so on and so forth. And so therefore medical data could come under that. I'm not sure. There is no prescription right now. So it could make a category of data that cannot flow out. Otherwise, I would read Rule 15 to mean that yes, data can be stored outside because there's no prohibition for it to be transferred unless restricted, provided the data fiduciary takes the full responsibility for the preservation of it, the protection of it, and the ability to access it.
Thank you. With that, I think we will have to call it a day. And what I can assure you from FICCI's side is that we will come back with more focused, webinars, which will take up maybe 3, 4 aspects of the law and the rules so defined. And it's my pleasant duty now to thank Tishampati Sen for having done research. Thank you very much. Having given his opinion, his wisdom, and also every time saying, let's err on the side of caution. And I think that those are wise words. Dr. Narayan Pense for bringing in the problems and the issues which affect service delivery in hospitals and in diagnostic centers, the practical aspect. We don't want that this affect patient delivery, care delivery, and that we are, just scared about getting the right consent, and in the process the patient health suffers. Very, very important points, because everything is actually based on the patient. The patient is the central figure in what the government is trying to do and what hospitals, providers, medtech, everyone is trying to do. And we need to actually interpret these things in such a way that the patient continues to benefit, because the entire healthcare industry is really here for patient. And then to Dr. Ansuya Rao, who brought in the apprehensions as well as the wisdom from medtech developers, be it software, AI, be it instruments, all of those, that these laws should in no way hamper innovation, should not hamper Make in India. And as it is, most of these large multinational companies today are focusing on making in India for the world. There should be no way that this law actually goes and affects that or hampers that or in any way pulls that back. So that's where, we hope to work further. We will have more of these in the coming years. We will take your feedback. Please do write to FICCI and let us know how you enjoyed it. Of course, everyone is thanking the three of you. Unfortunately, we didn't have much time for interaction within, because there were so many questions that were coming from those who had joined. So over to you, Shilpa. Thank you very much for this. You put together a brilliant program, very timely, and the response shows that we've hit the right chords. Over to you.
Thank you so much, sir. Thank you to you for leading it, for ideating it. It was a very insightful webinar. Thank you, Mr. Sen, for all the hard work that you've put in. And it seems that we will keep troubling you in the near future. And thank you, Ms. Rao.
I think his wife, Riddhi also would have done a lot of the research and helped him in that. He is getting all the credit. But
Riddhi, let me have that.
Yeah.
Thank you, Mr. Sen, and to your wife. Thank you, Dr. Pense. And we will keep in touch with you. The questions that we have received in the Q&A section also will, probably collate them, try to answer in the next section, and as Dr. Mahajan has advised. And thank you to all the attendees for joining the webinar and being with us till the end. Thank you. Have a good day.
Thank you very
so
much.
Thank
Enjoy
you.
your lunch.
Thank you so much. Thanks, everybody.
Bye-bye.
Bye. Take care.
Bye-bye.
Bye-bye.
Bye.